that I can't refer X, Y, and Z services to a particular hospital, but I know that Bill, he doesn't have ownership interest in X, Y, Z, but he owns ABC, and he can't do those services at his hospital. I refer all my patients to him. He refers all of his patients to me, and that's a cross-referral circumvention scheme, and that would be illegal. There can be additional monetary penalties as high as 3 times the amount of the improper payment for a claim that a person knew or should have known was improper, and the party may be excluded from participation in any federal health care program. What's a referral? A referral is defined as a request for an item or a service by a physician. It can be a request by a physician for consultation with another physician, and any test or procedure the other physician orders, performs, or supervises. A referral can also be a plan of care that includes the provision of designated healthcare services. Next question, what are designated healthcare services, or DHS? Designated healthcare services include clinical laboratory services, remember those were the original services, physical therapy, DME, home health, and the list goes on. But the last item on the list is inpatient or outpatient services. Now, lithotripsy was excluded from the list of designated healthcare services, even though we all know that we perform a lot of our lithotripsy procedures in hospitals as outpatients, and outpatient services are on the list. But because of a lawsuit that was filed by the American Lithotripsy Society, lithotripsy was specifically excluded from Stark. Laser services, on the other hand, which we also provide in hospitals and outpatient setting, are not excluded, and therefore we cannot have any physician ownership in our laser company. And we don't have any physician ownership in our laser company. What's a DHS entity? It's a lot of definitions. A DHS entity is an entity that bills for DHS services, or an entity that performs DHS services. For example, a hospital that bills Medicare for laser services that we provide under our contract, that hospital would be considered a DHS entity. Okay, here's where it's going to get a little more complicated, but what is a financial relationship? A financial relationship includes ownership interests. Ownership interests can be stock, membership interests, and it also includes compensation arrangements. Those can include any form of direct or indirect remuneration. In other words, where there's money involved. Lease payments, gifts, if they're valued over $300, stock options, medical director agreements, etc. What's an indirect ownership interest? Indirect ownership interest is an unbroken chain of 2 or more persons or entities with ownership interest. For example, Dr. Stone owns stock in Urology Holdings, and Urology Holdings owns 10% of the MRI Center of Illinois. The doctor doesn't directly own MRI Centers of Illinois, but he does indirectly because of his ownership interest in United Urology Holdings. United Urology Holdings owns it. So the next slide shows a diagram of this. You can see that Dr. Stone indirectly, through his ownership in Urology Holdings, indirectly owns the MRI Center of Illinois. So that's what an indirect ownership interest looks like. Okay, we've talked about indirect ownership relationships. Now we're going to talk about what's an indirect compensation arrangement. It's an unbroken chain of 2 or more financial relationships, one of which has to be a compensation relationship. So if you look at the doctors, even though they don't have a direct ownership relationship, they have an indirect compensation arrangement with the hospital. And they have a mixture, an ownership interest in United, and then because United has a contract with the hospital, they indirectly have that compensation arrangement with the hospital. If United was always paid a flat fee, such as, let's say, $10,000 per month, we wouldn't need to worry about Stark because there would not be an indirect compensation arrangement that varied with the volume or value of the referral. But because our arrangements are a per click or per fee arrangement, by any doctor that sends more patients to the hospital, the overall compensation that's made to United changes with the volume of services. And therefore, there is an indirect compensation arrangement, and that varies with the number of cases or the volume of services provided. This is a kind of a difficult concept to figure out because we know that our doctors are only paid based upon their percentage ownership in the company. But because the pool of distribution gets larger, as I mentioned, by the number of cases that a doctor refers, then the aggregate or the whole compensation increases, and therefore it could be a Stark violation. There's a Stark violation if the DHS entity, which I told you before could be the hospital, has actual knowledge of the indirect financial relationship and bills regardless. And that's why we find that a lot of our hospitals will ask us, and will ask Jim, does their doctor have any ownership interest in United? Because they want to know about that, and they want to make sure that if they have to report that they can report that ownership and that indirect financial compensation arrangement. If a hospital does ask us if a physician has ownership interest, we should tell them that the physician does. However, we expect that hospital to keep that information as confidential and as they can. And in some cases, we could have the hospital sign a confidentiality agreement that they're only going to disclose the information if they have to disclose it on ownership. Okay, so next slide, just to talk about this indirect ownership a little bit more. Dr. Stone, I'm going to give you the example, owns membership interest in United Urology Holdings. And United Holdings has a laser contract with St. Mark's Hospital. If Dr. Stone is going to refer to the hospital for anything other than lithotripsy services, like let's say he's going to do his surgeries there or labs, that indirect compensation arrangement must meet a Stark exception because of the lithotripsy and Dr. Stone's ownership interest in United Urology Holdings. That is why we care that even though lithotripsy is not a designated healthcare service, the hospitals are going to have problems with that relationship if the physician's referring any other type of designated healthcare services. And by not dealing with it, we've caused them to have a claim that's billed in violation of Stark. So it is a big issue. Here's a diagram again of the relationship. Dr. Stone indirectly receives compensation from Urology Holding LLC, and Urology Holding LLC is compensated via its contract with St. Mark's Hospital. If Dr. Stone refers patients to St. Mark's Hospital to receive laser services, the aggregate compensation to the LLC is going to vary with the value or volume of the referrals, and again, that's because we have per case payment arrangements and not flat fees. Okay, Stark exceptions. If a financial relationship exists with an entity and patients are being referred for designated healthcare services, then the activity must either comply with an exception or the activity is illegal. Exceptions with Stark are mandatory. There are 3 questions to ask when analyzing the physician self-referral law. Number 1, is there a referral from a physician for a designated health service? If yes, then the question is, does the physician or immediate family member have a financial relationship with the entity providing the designated health care service? If yes, does the financial relationship then fit into an exception? Safe harbors immunize certain payment and business practices that are implicated by the anti-kickback statute from criminal and civil prosecution under the statute. To be protected by a safe harbor, An arrangement must fit squarely in that safe harbor. Compliance with safe harbors for anti-kickback statute is voluntary, while we said that Stark exceptions are mandatory. There are 20 safe harbor areas that are all very complex and require legal review. For example, anti-kickback statute safe harbors include space and equipment rental arrangements, and each safe harbor then has multiple elements or criteria that must be satisfied under that safe harbor. For the space and equipment rental safe harbors, here's some of the criteria that must be met. The lease is set out in writing and is signed by both parties. The lease covers all the premises that are leased between the parties for the term of the lease and specifies the exact premises that are going to be leased. If the lease is intended to provide the leasee with access to the premises for periodic intervals rather than on a full-time basis, then the lease must specify exactly the schedule of services, their precise length, and the exact rent for those services. The term of the lease is not less than 1 year. The aggregate rental charge is set in advance, is consistent with fair market value in arm's length transactions, and is not determined in a manner that takes into account the value or volume of referrals that are generated between the parties. The aggregate space rented does not exceed that which is reasonably necessary to accomplish the commercially reasonable business purpose of the lease. So you can see that there's a lot of things that need to be taken care of under that example. Another safe harbor for anti-kickback statute, I'm not going to go into all of them, but there is a safe harbor area for investment in ambulatory surgical centers. The following criteria must be met. The terms on which an investment interest is offered to an investor must not be related to the previous or expected volume of referrals, services furnished, or the amount of business otherwise generated from that investor to the entity. At least 1/3 of each physician investor's medical practice income from all sources for the previous fiscal year or the previous 12-month period must be derived from the physician's performance of the procedures. The entity or the investor must not loan funds to or guarantee a loan for an investor if the investor uses any part of that loan to pay for his investment interest.
Can you explain that second one, 1/3 of each physician's investor medical practice income?
Well, I cannot really explain that except that, Bruce, do you know the answer to that?
I don't, but I think I might.
Okay.
I mean, we had a situation where we met with one of our doctors who's an investor in a surgery center, and he told us that they are required to do 1/3 of all of their cases that they are able to do at the surgery center, or it affects their distribution.
Oh.
So what was interesting is it's, you know, if he schedules a case on after hours or on Saturdays when they're not open, it doesn't count against that. But for example, if he were to do a case at our center on a Monday at 2 o'clock, when he could perform that at the surgery center, then that would count against that 33%, and it would somehow affect his distributions.
Well, that's,
Okay.
that's not the government list, the surgery centers.
The surgery
But it's
center's-
probably based,
But it's,
Harbor.
but it's,
yeah, it's because they're trying to keep that safe harbor requirement.
right.
So you're saying if the surgery center requires that doctor to do 1/3?
Right.